What's the difference between a vacuum and a lawyer on a motorcycle? The vacuum has the dirt bag on the inside.
What kind of happens if maybe we didn't have an ironclad contract with appendices and like 13 pages of legal jargon?
You're a proponent of the Burr method. I'm a proponent of the Burr method. It's a great way to force value and force appreciation. But you really need to know your team. You really have to have skilled people behind you. And today we're going to talk about what happens if you don't. My plan is by the end of this talk, hopefully your audience will have an idea of, regardless of the problem they're having with real estate, by the end of this chat, they should have an idea of where do I go to solve it? How long is it going to take to solve it? How much is it going to cost to solve it? And so if I can answer those questions, hopefully I'll have done my job today.
What is up, YouTube? Matt McKeever here, and in today's video, we're going to be talking to Weston about what exactly happens when things go wrong with your real estate transaction. So particularly, we're going to be talking about what happens when you're buying a property and the deal falls apart, or what happens when you buy a property and things aren't the way they were supposed to be after you close on the property. Weston's the guy you kind of want to call to solve your problems in these situations. So thankfully, in my career as a real estate investor, I haven't had a lot of need of these services, but when it is necessary to solve your problems, you want to make sure that you've got an expert on your side, someone that's really been there, done that, got the t-shirt. You don't want to be someone's first case when it's kind of going into this realm, because it's scary for us, right? Whether you're looking at small claims court or I forgot what the name is right now, because again, I don't want to be there. I'd rather have a lawyer go be there on my behalf. But anyways, we talk about all this stuff and a lot more in today's video with Weston. I think it's a one-of-a-kind video. I suspect it's maybe one of the best videos we've ever done on this channel. So if you guys get value from it, smash the like button, hit subscribe, and let us know what other questions, what other concerns, what other scenarios would you like to hear Weston talk about on this YouTube channel. Let us know in the comment section.
What is up, YouTube? Matt McKeever here, and I'm really excited for today's video. We're going to be covering a subject matter that I know a lot of you have questions about, but we've never really explored or dived deep into. So we've got an expert today on the channel, Weston Powell. Hey, Powell, how's it going?
Going well, thanks. How are you?
Good. And so really excited just to kind of break down for the audience what's going on when it comes to litigation, right? So I think, honestly, for the average Canadian, our exposure has probably been US TV. And I'm imagining that that's probably not the absolute best example for us to be using as real estate investors. So I know you've put together a presentation, but before we jump into it, Weston, do you want to just kind of break down for us, you know, what it is kind of you do, and even just like maybe even the definition of litigation, just to make sure that we're talking the same language with the audience?
Yeah, that's a great idea. So a little bit of background. I'm a real estate litigation lawyer. And I think what Matt's talking about there is there's confusion sometimes with lay people between transactional real estate lawyers, those lawyers that help you buy a house, sell a house, buy an investment property, sell an investment property, and litigation lawyers like me that you really only call when something's gone horribly wrong. And hopefully you'll never have to make that call, but it does happen. I know that Matt's had other great transactional real estate lawyers on, and so those are the people that you call when you want to buy or sell property. But usually those are not the same people that will help you when a problem arises. It's a totally different skill set, totally different area of law. And so what myself and my firm do is we help people when things go wrong, and it can happen in a number of ways. It can be that the property fails to close in the first place, whether you're the buyer failing to close or you're the seller and you're frustrated because the buyers failed to close, or it can be that you, after closing, have found a latent defect, like a major flooding issue that wasn't disclosed prior to the deal closing, or you've bought a property and you're doing some construction, and we're going to dive into that a bit today. What happens if the construction goes sideways and you and your contractor aren't seeing eye to eye and you're having some legal issues there? So a number of issues that can go wrong with real estate, and that's all my firm deals with. We do not do any transactions. We only help people that are in a tough spot.
Mm-hmm. Yeah, really appreciate that. And let's maybe jump into the presentation. I might pepper you with questions because I know that the audience definitely has a lot because I see them in my comment section all the time.
As far as myself, my bio is, like I talked about earlier, I'm a real estate litigation lawyer. I've been doing it for 6 years. We serve all of Southwestern Ontario, so we're not just limited to the GTA, but we do service all of Southwestern Ontario. On top of that, I'm a real estate investor myself, so I do see things both as a lawyer and as a real estate investor, so it's good to have both of those caps on sometimes. Oh yeah, mandatory lawyer joke. So anytime I do any kind of public speaking, I think a lawyer should always have some kind of a lawyer joke. So the joke is, what's the difference between a vacuum and a lawyer on a motorcycle? The vacuum has the dirt bag on the inside.
There you go.
What a litigator does, we actually already talked about that. So we don't do transactions, we just solve problems, and it can be contractor disputes, failed closings, latent defects, realtor negligence. Sometimes your realtor doesn't do their job properly and you buy something that is not at all what you anticipated, and realtors are held to a certain standard. If they fall below that standard, you might have a case against them in court. Again, that can be another interesting topic for another day, but that's another very common call that we tend to get. So today, yeah, like I said, we're going to talk about what does a construction dispute actually look like in terms of where do you go, how long does it take, how much does it cost, what do you need to win, how can you protect yourself before you even get to that problem. And in the background, we'll talk about sort of just how the courts work in Ontario to begin with. So my plan is by the end of this talk, hopefully your audience will have an idea of, regardless of the problem they're having with real estate, by the end of this chat, they should have an idea of where do I go to solve it? How long is it going to take to solve it? How much is it going to cost to solve it? And so if I can answer those questions, hopefully I'll have done my job today.
Awesome.
Okay, so negligent contractor. So probably the most common call that we get is someone calls and says, hey, I retained this contractor. I paid $30,000 up front. They came, they made a huge mess, and it's been 6 months, they've left and nothing else has happened. What do I do? And it floors me that this happens as often as it does. And there are, don't get me wrong, there's lots of great reputable contractors, and there's, you know, you're a proponent of the Burr method. I'm a proponent of the Burr method. It's a great way to force value and force appreciation. But you really need to know your team. You really have to have skilled people behind you. And today we're going to talk about what happens if you don't. What happens if you, for whatever reason, even if you've done your due diligence, sometimes things slip through the cracks and you get in a hard spot. So let's talk about that situation. Let's talk about what happens if you hire a contractor, they come, they make a big mess, you paid them a bunch of money, and now they're gone in the wind. What do you do? So the short answer is you can sue them, and there's a couple reasons why. The first is negligence. So when I say cause of action, it's just a fancy legal term for what are the reasons you get to sue these people. One is negligence. So they do have to be held to a certain standard. And so for workmanship, for example, if a general contractor comes and does nothing to code, and doesn't do permits, doesn't pull permits or anything like that, obviously that's negligent. And so you can take them to court and sue them for damages. Similarly, if you have and we'll get to why this is so important, but if you have a contract and they breach it, obviously you can sue for that too. So if they said, we'll do the whole job for 100 grand, usually it's broken down into stages, right? Like stage 1, 25 grand, stage 2, another 25 grand, etc. But if you've got a contract like that and they haven't lived up to their end of the bargain, you can sue them for that. You can sue them for breaking that contract. And so as far as what you're actually entitled to, because like you said, so many people watch American television and they think, I've got $1 million case.
Yeah.
I'm so annoyed. They've ruined my family's life for a year. We had to go live in a hotel for a month. And, you know, on a personal level, yeah, it's infuriating and you're very upset and you feel like you're owed the world. In Canada, that's unfortunately not usually the case. Punitive damages, as they're called, are very rarely awarded in Canada. It's a different situation in the States, but generally speaking in Canada, what you're actually going to get if you go to court and sue somebody are damages for breach of contract. So for example, if they said, we will do the drywall and replace the floors and do all the painting and do the kitchen for $45,000, something like that, and they don't do it, but you paid them the money, you're entitled to get that money back, obviously, right? They've broken the contract, they didn't hold up their end of the bargain, you can get that money back. But if you wanted to sue them for $1 million because it also ruined your life and maybe put you and your wife on the rocks or something, no, not going to happen. And I always sympathize with my clients because I know how frustrating the whole process is. But it's important when you're going into litigation, go in with eyes wide open, have reasonable expectations because not every case is $1 million case. As well, I've written down here, damages have to be reasonably foreseeable. So by that I mean, if you say, well, the project didn't finish, and as a result, I lost my job, and as a result of losing my job, I lost my wife, and now I'm suing you for $1 million because you ruined my life. No, because that wasn't reasonably foreseeable. A contractor wouldn't, he might expect, if I don't do the job, you're going to incur some expenses by having to hire a new contractor or something like that. But it's not reasonably foreseeable that your whole life would crumble. So when you're trying to figure out what your case is worth, bear in mind that those damages do have to be reasonably foreseeable.
Yeah, really appreciate that perspective. And I might be jumping ahead here, and if I am, just stop me and we'll pick it up when you've got it in your presentation. But let's kind of talk a little bit about the contract aspect there, the breach of contract. So I'm assuming you come across or probably have came across it where, a handshake or back of an envelope, or we sent one text message back and forth, and that was really all that we had. And now, I'd love to hear some best practices in your opinion when it comes to drawing out some of those contracts, or I assume having it in writing is step one, but, what kind of happens if maybe we didn't have an ironclad contract with appendices and like 13 pages of legal jargon?
Yeah, the short answer is it makes my job a lot harder at the end of the day. Because you're usually only entitled to whatever the contract said you're entitled to. So if the contract just says we'll do the job for $50,000 and doesn't say when it has to be done by or what exactly is the scope of work, when you say the whole job, does that mean the pot lights in the ceiling? Does it mean what exactly is the scope of work? So to your point, extremely important that you reduce it to writing. And we are jumping ahead, but that's okay. I'll talk about some of the things you can do to protect yourself. So one, and you've done actually a really good job. I'm a big viewer of your channel myself, so I know you talked about these things, but really important that you check references so that it's really easy to throw up a fancy website or get some Google reviews or something like that. That does not necessarily mean they're a reputable contractor. The best way to check somebody's work is to speak with someone who's actually worked with them on a similar project, right? Because a handyman can do certain things, but they can't do a basement renovation or a duplex conversion, right? So you want to get the right people on your team, and to find those people, you should be checking the references and say, okay, they did similar work for you. How long did it take? What did they do? How much did it cost? And get a sense of just how professional they really are. So that's the first thing, check references. Number two, make sure that they've got insurance because there's a lot of liability on you as the owner. If somebody gets hurt on the site, and they don't carry insurance, that's going to be falling on you, and that's potentially a huge exposure, a huge liability. So make sure you check insurance. And then obviously, paper the deal. Make sure that the contract is not only in writing, but it sets out exactly what the scope of work is, whether you're paying for labor on its own or you're paying for materials. Usually as a consumer, it's in your best interest if you're setting out, well, here's what the supplies are going to cost, and here's what the labor is going to cost. And that way you can do an apples-to-apples comparison. So when you're going to other contractors, you can figure out, okay, it's not just a lump sum figure of $20,000 to get the job done. It's these people are saying it's $5,000 in materials and $15,000 in labor. So you can actually figure out what it is that they're doing for you. So have a really detailed scope of work. Another thing you can do is check their ID. Because the worst thing that can happen, and we get these calls too, is when someone ghosts you, right? So they say they're with XYZ Contracting, you pay them a bunch of money, and you literally never see them again. And all you know them as is XYZ Contracting. That's who you signed the papers with. But you do some Googling, you do some searching, you find out XYZ isn't even incorporated. It's not an actual entity. So if you wanted to sue somebody, who are you even suing? You don't know because you don't know their identity. So whoever you're dealing with, even if they're incorporated, even if it's a good contracting company and they're incorporated and can show you their papers, which is a very easy thing to ask for, by the way. You can ask, show me your articles of incorporation or a status certificate, something showing that you're actually a going business. That's one thing you can do. But I like to, whenever I'm dealing with someone, literally get a copy of their ID so that if John Smith screws me over, I know I'm dealing with John Smith, who lives at 123 Appleby Lane. And if I have to take legal action against him, I know who my target is. I know who I'm actually going to court with. So at a minimum, those are some of the things that you can do ahead of time so that you don't have to call someone like me. Really you would want to be talking to a solicitor, and not to bore your audience with jargon, but even those people, it's an entirely different skill set, like drafting of contracts. My firm doesn't actually do that. We really only get involved when someone's broken the contract. So I'm not sure if the other real estate lawyer, Ryan, I think, from Carson Law,
Yeah.
not sure if they would do that for your audience, but that's a really good idea. Before you commit to a huge amount of money and potentially, a year's worth of renovations, you're going to want to have it really well papered, and a lawyer is a great way to do that.
Yeah, really appreciate you sharing those tips. And just to summarize for everyone, it really is like you can't enforce what wasn't written down, right? And the devil's in the details here. And so again, when we're trying to protect ourselves, what you want to do is try and be as explicit as possible with what you've agreed to. So if you agreed that phase 1 of the job was going to be done by June 30th, put on June 30th as the date there. And if phase 2 is September 30th, put that date, because again, handshake agreements and best of intentions sometimes don't end up getting us the results we want. But as long as it was spelled out in a contract, someone like Weston can step in and really help quarterback the situation for us.
Yeah, exactly. And so I actually didn't do a very good job of answering your question. You said, what happens if we don't? What happens if we don't have it well laid out? Short answer is I can still do my job. I can still take someone to court and sue them. It's just harder for me to prove your case, because if it's just a verbal agreement, you're going to say, well, they said phase 1 was going to be done by June, and they're going to say, no, we never said that. Prove it. And it's your job to prove it. As the plaintiff, as the person bringing your case, it's your job to prove it. And we can rely on other things besides contracts. So another good thing to do, another rule of thumb or something, is keep written communications, keep records of written communications. So if there's emails back and forth or text messages back and forth, those are all valuable things that I can use later on to prove your case. And I can show, well, we don't have a written contract per se, but we do have text messages back and forth confirming this is what it was going to cost, this is when it was going to be done by. So yeah, keep those records.
Yeah, really appreciate that, Weston. And one other tip here as well, guys, is again, when you are doing those phone verbal communications, don't be afraid to send a summary text message or email afterwards, just getting the person to kind of confirm, like, hey, I've got a bad memory. So just to summarize, we agreed to these as our next big dominoes, or the big steps, or the cost. Or again, sometimes contracts get changed, right? Maybe we amended it, or we agreed that actually I do want a hot tub now, so I will pay the extra money for it.
Yeah, that's actually a really good point, because that's something that comes up often. Is they might have a fairly detailed contract for the original scope of work, but then there's add-ons after the fact, right? Maybe you want better finishing touches. You want quartz countertops, or you want pot lights instead of regular fixtures. Make sure that that's really documented, really well documented, whether it's emails, text messages, etc. Make sure that's written down, because if all you've got is the original contract, it makes my job harder at the end.
Yeah, absolutely.
So in that case, we'll stick with something simple. Let's say that you're just renovating, living room, kitchen or something, and the amount of work is less than $35,000. So one of the things that you've got to think about before you even go to litigate is which court should you be going to in the first place. And so in Ontario, we've got 2 civil courts. We've got the small claims court, and we've got the superior court. So small claims court has jurisdiction to handle any matters involving amounts of $35,000 or less. So if the person you're suing, if the amount of money that you want from them is $35,000 or less, great, small claims court is the way to go. If it's more than that, superior court is where you'd have to go, because you can't sue for anything over $35,000. And sometimes people have a tricky decision to make. Well, what if my amount is $40,000? Should I go to small claims or should I go to superior? The answer is usually small claims. And what happens is, even though you're technically owed $40,000, you can waive the extra $5,000, keep it in small claims court by only suing for $35,000, and go through there. And people, when I have that conversation with them, one of the things they ask is, well, why would I do that? Why would I give up $5,000 that's owed to me when I could just go to superior court? And my answer to that is, small claims court is way faster, way cheaper. So yes, you're giving up $5,000 of your claim, but if you're saving $15,000, $20,000, $30,000 in legal fees, it's money very well spent.
Yeah.
Other things to think about before you start litigation is, do you have time to sue? A lot of people don't realize that there are limitation periods in Ontario. And a limitation period just means there's a certain amount of time where you have to sue someone. You have to start a case in court. And if you don't, you lose that right. You lose it. It's statutorily barred. Your case will get thrown out. So the limitation period, it's kind of a technical area of law, but generally speaking, it's 2 years. It's 2 years from the date that you knew or ought to have known that you had a case. So for example, if your contractor walks off the site, has made a big mess, and you paid them a bunch of money, you've got roughly 2 years from that date to bring an action. And if you don't, if you wait 3 years or 4 years or however long, you'll be out of luck and you'll be out of time and you won't be able to pursue them. So it's a generous amount of time, but just be mindful of the fact that you don't have forever. There's only a certain amount of time.
Mm-hmm.
Another thing to think about before diving into litigation, and this is really, if it was me taking someone to court, this is the first thing that comes to my mind is, am I going to be able to actually get the money? Because it's all well and good to have, a Pyrrhic victory and take someone to court and great, I got a judgment. The judge says that you owe me the money. That's step one, right? Like, there's a very big difference between getting a judgment and actually getting the money from the other side. Most people, when they're served with a judgment, don't just write you a check, especially contractors. You've got to go get it. And so when I'm debating whether or not to pursue litigation, I want to think about, okay, assuming I can win, assuming I can go and I can get a judgment and the judge is going to tell the other side that they have to pay me, how can I go get it? And there's different ways of doing it. Usually the best way are liens. So if you know that the contractor owns property in their own name, great, wonderful target for litigation, because at the end of the day, once you do have a judgment, you can then go put a lien on that person's house, and that effectively prevents them from refinancing it, selling it, really dealing with it in any way until they've paid you back. So that's a great green check mark. If somebody owns real estate, you can pay a lawyer, you can pay a bunch of people to find that out for you, to do some searches. It's like $100 to pull a PIN search and figure out whether or not the person owns property. I would do that before doing anything. Another way to collect a judgment is garnishment. And this can be really tricky with contractors, right? Because they're self-employed. So it's not like they're a lawyer working at a law firm and you know where they work, and if you get a judgment, you can simply serve their employer with a notice of garnishment and say, hey, every paycheck until he pays me back, you have to give me 20% of his paycheck. That's easy. That's really easy if they're employed in the usual course. But people like contractors that are self-employed, totally different scenario. They are the employer. You can't just serve them with a notice of garnishment and expect them to pay you. So one thing you can do is, if you know where they do their banking, if you know, and it's not as simple as saying, oh, they do their banking at TD, you need to know the branch address where they do their banking. And so that might be something else that you try to get ahead of time. If you're being, I'm really lawyering it now, but if I was being really careful, I would want to know, where do you do your banking? So that at the end of the day, if things go south or sideways, I know where I need to go to try to get my money, if it comes to that. So those are some of the things you'd want to think about before you even dive into litigation. We talked about how to protect yourself, checking references. We didn't, one thing to think about, or to protect yourself, holdback requirements. So, I don't want to go into that whole can of worms, because it's a really technical and complicated area of law, and maybe we'll do a whole other talk about it. But the takeaway for today is, you as the one paying for the project do have a holdback requirement, regardless of what your contractor says. And a lot of contractors, especially smaller players, aren't even aware of this. But you have a legal responsibility, whether they know it or you know it, to hold back 10% of the project funds. So for simple math, let's say it's a $100,000 job. You've got to hold back 10 grand until 60 days after the job is done. And the reason for that is it protects the sub-trades, because you're dealing one-on-one with a contractor. You've contracted with them. I'm going to pay you 100 grand. You get the job done. Great. But what happens if that contractor doesn't pay his sub-trades? And so the reason why we've got that legislation in place is to protect those sub-trades, so that you, the owner, have to hold back 10 grand. And then if a sub-trade hasn't been paid, they can put a lien on your property and you can give up that 10 grand that you've been holding. And that's really all that you're legally liable for. But if you don't know about this and you don't hold back the money until 60 days after the job is done, let's say I contract with someone, a general contractor, to do $100,000 worth of work. I pay them $100,000. I think, great, I've done everything right. I've paid them in full. It's over. No, a sub-trade can come out of the woodwork, put a lien on your house, and say, you, owner, are responsible to pay me $10,000. And you think, why? I've paid in full. What are you talking about? And it's because you do have an obligation to withhold or hold back those funds until 6 days after the job is done. So make sure you know that. Make sure that you're talking to a lawyer and that you understand that if you pay that money, if you release that money early, you could potentially be responsible to someone else for that 10%. Does that make sense?
Yeah, really appreciate you breaking that down for us, and a really important part that doesn't necessarily always get covered in these conversations.
Yeah, especially for smaller jobs, right? But most trades do use sub-trades.
Yeah.
You're not usually the guy that you're contracting with is not the guy who's going to be swinging the hammer and getting everything done. He's just the organizer. He's the person, getting all the sub-trades in place and organizing and making sure the job gets done in a timely fashion. But you're responsible, even if you don't have a direct contract, you are responsible to those sub-trades. And how you protect yourself and how you protect them is by holding back that 10%. So that's a common issue that comes up, is having to sue contractors. I'll talk a little bit, and interrupt me at any time if you have any questions.
Sure.
But I'll talk a little bit about the differences between small claims court and superior. So small claims court, like we talked about, $35,000 or less. Something that people don't realize about small claims court is it does have a very limited jurisdiction as to what you can actually sue for. So the small claims court can only help you with two problems. It can make people pay you money, or it can make people return property to you. Like if you gave someone an engagement ring or something, they could force that person to give back that property, that engagement ring, back to you. But that's it. Money and return of property. That's all the small claims court can do, which is usually all you want in the first place. But sometimes it gets a little more complicated. Sometimes you want to force someone to sell them the house, right? We had an agreement. Now the sellers were negging. And I don't want the money. I want the house because I've got great plans. Maybe I'm going to burn it or whatever. In that case, small claims court can't help you with that. Never mind the fact that it's way over the $35,000 limit. It's also not something that they can force someone to do. In order to force someone to take a positive step that's beyond paying you money or returning property to you, you've got to go to superior court. And so we call that like a mandatory injunction. If you want someone to move a fence onto their side of the property, because right now it's on your side of the property, small claims court can't make that order. It has to go to superior court. You want someone to have to sell you the house, you'd have to go to superior court. Small claims court can't do that. Does that make sense?
Yeah, really appreciate you breaking that down for us. And I guess one of the things that I know the audience, they're naturally going to jump to or be curious about when we hear, faster and cheaper or longer and more expensive. Are you able to give us some relative numbers there or perspective?
Yeah, no, absolutely. It's my next slide, in fact.
Awesome.
So economics of litigation, because especially your audience, they're investors, right? It's all about return on investment, dollars and cents. And, those are actually the best clients. The worst clients are the ones whose faces are turning red and it's about the principle and they're deeply displeased. That can be very difficult to have good conversations with, because at the end of the day, my job is to maximize your return, not to win on principle. So as far as legal fees go, every firm is different, but I can give you some sort of guiding principles. Small claims court, in my opinion, you shouldn't be paying more than around $5,000 from start to finish. My firm is somewhat unique in that we do things on a flat rate basis. So rather than paying by the hour where, oh no, the meter's running, who knows how much it's going to cost, which is a very scary thing for a consumer, it's just, no, it costs this much to do a plaintiff's claim, it costs this much to go to a settlement conference, it costs this much to go to a trial, period, flat rates. And our fees are around $5,000 for that whole process. So that's the cost of small claims court. And while we're talking about small claims court, because another question your audience is going to have, and that I get all the time is, okay, well, I'm paying you money to go try to win some money for me. What about the money that I paid you? Do I get that back? And the answer is yes. It's generally, it's always up to the judge. In small claims court, they're called deputy judges. And it's entirely at their discretion. But generally speaking, they order the loser of the lawsuit to pay the winner of the lawsuit something for their costs. And so it's a little interesting. In small claims court, it's different than superior court, but in small claims, the most that the judge can order the loser to pay the winner is 15% of the amount they're suing for. So it actually has nothing to do with how much money you spent on your lawyer. It has everything to do with how much are you suing for. So, the most that you could get back in terms of legal fees is 15% of $35,000, $35,000 being the most that you can sue for in small claims. So really the most that you can ever get back to cover your legal expenses is $5,250, 15% of $35,000. So that's why, in my opinion, you shouldn't be paying more than $5,000 because even at the best of times, when you're suing for the maximum in small claims, that's all you're going to get back anyway. So if you go with another firm that charges you $10,000 or something, great. Maybe they'll get you a victory, but bear in mind you're only going to get at most $5,250 of that back, and the rest is out of your pocket. And often in small claims court, you're not suing for the maximum. Often, we see cases for $10,000, $15,000, $20,000, and so you'd only be entitled to 15% of whatever it is that you're suing for. So that's how it works in small claims. Superior court, totally different game, totally different situation. And the reason for that is, unlike small claims court, that's a pretty straightforward 3-part process. You're going to draft your plaintiff's claim, the court document that sets out who you're suing, how much for, why you should win. Then you're going to go to a settlement conference where hopefully the two of you can figure something out. If that doesn't work, third and final step, you go to a trial. Really simple, straightforward process. The whole thing takes about a year under normal circumstances. When it's that straightforward and always follows the same process, we can charge flat rates because we know what we're getting ourselves into.
Right.
In superior court, it's a different ball of wax because it doesn't usually follow a really neat path. It does follow certain steps, but there can be a bunch of motions involved, or there might be a lot of documentary discovery, or there might be a number of witnesses that we need to interview and create transcripts. It can go a bunch of different directions. So unfortunately, I can't give flat rates, but I can give you an idea of roughly what it costs. So really what you're paying for in superior court is the hourly rate of the lawyer and his team. So the lawyers at my firm, for example, they charge $300. I charge $350, but my associates charge $300. And that's sort of the going rate for people with our level of experience. We're sort of mid-career litigators. We're not green, but we haven't been doing it for 20 years either. You can pay a little less than that if you're getting someone who's really green and fresh, or you could pay a lot more. You could easily pay $600, $700 an hour if you're hiring someone on Bay Street who's been doing it for 30 years and has a certain level of expertise. So I can't speak for other firms, but for myself, if it goes all the way to a trial in superior court, and I should preface this by saying, especially in superior court, most things do not go all the way to a trial. Most things actually settle. And the reason for that is because it is such an expensive process. Most people would rather just, and there's also a huge element of risk, right? Because even if you have a strong case, there's always a chance that a judge won't see things your way.
Yeah.
In which case, not only have you spent a bunch of money on your own legal fees, but if you lose, maybe you've got to pay something for the other side's legal fees. So in my experience, like 95% of these cases in superior court do settle. And it's a good thing. It's in everyone's best interest. But if it does go all the way to a trial, you could easily spend $25,000 plus. And so that's another reason when you're thinking about, well, should I go to small claims or should I go to superior? If it's close, if it's $40,000, $45,000, it makes sense to go to small claims, right? Whereas if it's $100,000, $200,000, $500,000, go to superior court. Even with the added expense, the added legal fees, it does make sense. It's a good return on investment. And then as far as, well, okay, now we're spending even more money on lawyers. How do we get that back, and how much of it do we get back? And it's different than small claims court. In small claims court, it was a percentage of what you're suing for. In superior court, it is based on what you've actually spent. How much have you spent on your lawyer? And that determines how much you get back. Entirely at the judge's discretion, but generally they order the loser to pay the winner 60% of what they actually spent on legal fees. Gotcha. So if you spend, to keep the math simple, if you spend $10,000, and you probably end up spending more. If you spend $10,000, you might get $6,000 of that back. Does that make sense?
Okay. Yeah, gotcha. And then I'm sure that obviously every case is unique to itself, and it's hard to predict, but are you able to give us like ballpark figures or ranges, even maybe if it's just for small claims court? Like, are we talking months, years, decades to kind of get to resolving things? And then again, if you can give us any sort of perspective on superior court. Yeah,
good point. So small claims court timelines, the entire process from start to finish, generally around a year. Basically, the steps are you start the lawsuit with a plaintiff's claim. 20 days after that, they have to file their defense. Usually you have a settlement conference a few months after that. If it doesn't settle at the settlement conference, you set it down for trial, and you might wait 4, 5, 6 months before you get a trial. And so if it does go all the way to a trial, you're looking at around a year.
Gotcha.
In Superior Court, it's a much lengthier process, unfortunately. And because a lot of things can get in the way, like added motions and things like that, it does range, it does vary widely, but I would count on it if it doesn't settle. And in my experience, most of them do settle, and most of them settle at mediation, which by that point you've spent about 9 months to get there. So
Gotcha.
it's sort of, if it does settle, it'll probably happen at mediation, which is around 9 months in. Could be sooner, could be later, but that's sort of a rough ballpark. If it goes to a trial, it takes a lot longer. And sadly, it's because our court system's overwhelmed and the court simply doesn't have enough court dates to have you over for a trial. So the trial wait list, for example, in Toronto is something like 2 years right now. So just like, even once you've jumped through all those hoops and now you say, okay, set us down for trial, we're ready, let's go. They say, great, wait 2 years and we'll get to you. So Superior Court, yeah, if it doesn't settle, potentially years, 2 to 3 years would be a reasonable ballpark.
Gotcha. Yeah, really appreciate the perspective, and something I haven't had to personally learn. Hopefully I never do, but I'm glad that we can learn through you and your experiences here.
Yeah. Speaking of timelines in Superior Court, so what I just talked about was if you're suing for damages, because we've been talking about contractors, which is what you'd be suing for. Other times you might be, again, not to get into the nitty gritty, but sometimes you might just want an application. So not an action, but you just want an application where a court decides, yeah, actually the fence should be 3 feet that way. And that does not take years. That sort of, like, you just need the court to weigh in on something really simple, like basically interpret a survey. That only takes a few months, like 4 to 6 months. So very different timelines involved depending on what you're trying to accomplish. If you have a really discrete, simple issue like figuring out where a fence should go, it won't take you very long. If you have a very challenging dispute where you're trying to figure out what work was done and what was promised and how much of the actual damage is, that can take a lot longer.
Awesome. Yeah, really appreciate this. And again, I feel like I've taken kind of a master's course so far here, but yeah, how are things impacted now with COVID? Yeah,
so it was very strange in the beginning, in March of last year, I guess. We had no idea how this was all going to play out. And so they shut everything down because all our judges are old white men and they were worried they were all going to die of COVID. And it takes decades to train and replace judges, so they just couldn't take that risk. So they shut everything down, couldn't do anything. That was pretty short-lived. Everything's reopened. You can start your lawsuit in small claim court. You can start your actions in Superior Court. We're basically just doing everything remotely now. So the same way you and I are having this monthly exchange, that's actually how we're doing court now. It's in some ways, COVID has been a blessing for the legal field or the legal profession because we were in the Stone Ages. I mean, we still wear robes to court, and we still wear robes now on Zoom. But at least we can do things remotely now where we're not. That's why I can service all of Southwestern Ontario because I'm not going to be driving to London. I can just sit at my desk and argue a motion. So in some ways, it sped up our technological innovation, and that's great. The short answer is we're right back to normal, and maybe even better than normal. And the other thing that's changed is because we were shut down for a time, limitation periods have changed somewhat. So earlier we were talking about how you only have so long to bring a case. Generally speaking, it's 2 years. There's a number of exceptions to that. So if you want a concrete answer, talk to a lawyer. But generally it's 2 years. Because of COVID, the courts decided, legislation actually decided, we're going to pretend like the clock wasn't running between March of 2020, March 16th of 2020, and September 11th of 2020, which is something like 6 months. And so what that means is when you're figuring out, okay, I've got 2 years to sue, but really, since it happened, during this time frame, I've got 2 years and 7 months, 8 months. So all it means is you've got a little extra time. Normally, you'd only have the 2 years, but technically, the clock wasn't running between March 16th of 2020 and September 11th of 2020. So you probably have a little more time than you would otherwise. They just wanted to make sure that people are already getting screwed over tremendously because of COVID. It would be really gross if people weren't allowed to enforce their legal rights in court because of COVID. That would have been a disaster. So that's where we are, if that answers the question.
Yeah, really appreciate that, Weston. And again, I appreciate you breaking it down kind of by the different sections or courts here for us.
Yeah, so that's basically, I think that's the end of the presentation. Yeah. So yeah, questions, or I know I was kind of rambling there for a while.
No, that was amazing, Weston. I really do appreciate it. It's a subject matter that honestly, I think there's a lot of fear and confusion from the average investor around, right? Like I wouldn't be shocked to learn if there's people that have probably been sitting on situations and they're almost scared to even pick up the phone because again, like legitimately a lot of us, our exposure is through cable TV and stuff like that. And you hear like lawyers charge $1,000 an hour and you're like, is it worth the $10,000 contractor that kind of screwed me over? Maybe I should just eat that. Should I just call my insurance company? You know, what do I do? And I think it's just so important people get comfortable having these conversations, understand the rules and regulations around the situation you find yourself in. And then again, we can be proactive and try and protect ourselves by implementing some of those best practices you mentioned in a contract. But again, at the end of the day, if someone still, you know, maybe they had bad intentions, maybe things just went sideways during whatever our renovation. If things aren't going according to plan, it's important as investors, we understand all of our options, the potential implications of them, and then choose what's best for us based upon that situation. I really appreciate you bringing the perspective of ROI to this conversation as well, because at the end of the day, as an investor, like you said, few of us are going to really want to lose money on a moral crusade here. It's about, you know, will I be compensated fairly for whatever damages or situation that, you know, maybe the contractor failed to do. Yeah.
Just to touch on that. So something I should mention is, especially in small claims court, there's no legal obligation to have a legal representative. You can go to small claims court on your own. Some people do it. It's really just a matter of your comfort level, and especially as the figure, you know, the amount in question starts to go up, it makes more sense to hire a lawyer. But because some people are wondering right now if they're watching this and they think, like, well, it's a $5,000 dispute. Is that enough? Does that make sense to hire a lawyer? And honestly, the answer is no, right? If it's a $5,000 dispute, you might want to go to small claims court on your own. You can file the forms online. You can go to the settlement conference on your own. You can go argue your own trial. Obviously, you're not going to have the same, you know, success rate potentially as you would with a lawyer, but you could still potentially win, and you're not spending all that money on a lawyer, because at $5,000, the most that you can get back in legal fees is 15% of that. So what is that, like $750? That's nothing, right? That's way more than you're going to spend on a lawyer. So for amounts less than $5,000, still go. It still makes sense. Go do it yourself. The filing fees to go to small claims court are still relatively affordable. It's $102 to file a plaintiff's claim. If it doesn't settle, you have to go to a trial. I think it's like $250 to set down a trial date. Those are included, by the way, in our flat rates. But if you're doing this on your own, you can do that, and it's, you know, relatively inexpensive. So for really small disputes of like $5,000 or less, if you want your money, you can still do it. You would just do it yourself, because it wouldn't make sense to hire a firm like mine. But as soon as you get to like 10,000 plus, in my opinion, it makes sense. But obviously, you want to crunch your numbers and see if that works out.
Yeah, absolutely. Again, just really appreciate you bringing your wealth of knowledge to the YouTube channel. I'm sure this probably sparked a lot of questions and situational, you know, investors viewing themselves in their own situations. So for anyone watching this at home, if you guys have any questions, jump in the comment section, let us know. We are looking at doing future videos together as well. So I'm sure people are going to have all kinds of different questions. I know one of the videos in the future I look forward to exploring potentially, it's just some of the more interesting novel scenarios or situations. I'm sure that there's lots of lessons we can learn there, or maybe situations where clients didn't set you up for success, and, you know, how we can make sure going forward as real estate investors, you know, if there's like one little form you can fill out, or just, making sure you send that in written as well as verbal communication. Those are really the tips, can make a huge difference for everyone involved in these situations. So again, really appreciate it, Weston, and really looking forward to exploring this subject matter further in the future. But for anyone that's watching this at home, we've got a link in the video description down below to all of Weston's contact information. So if you want to get in contact with him, or just Powell Litigation in general, we've got all that information. I really encourage you guys. You know, we talk about this all the time, but as a real estate investor, a huge aspect is building up your power team. and your power team is having experts that you can rely upon that have been there, done that, got the t-shirt, they've got the experience and the insight, so that we don't necessarily have to be an expert in everything, and we can really focus on being the expert when it comes to real estate investing. So if you guys find yourself in a unusual situation, a situation where you're frustrated with a contractor, I do want to encourage you to reach out to an expert like Weston, and we've got his contact information in the video description down below. Before we wrap up, any other last words of advice or wisdom for our aspiring investors on the channel, Weston?
No, actually, but before we go, I'll say I want to thank you. You know this. I'm an avid follower of your channel, and I think it's just awesome that you put out so much great free content as a real estate investor. I appreciate it, and I know your audience does too, so thank you.
Awesome.
Thanks again to Weston for taking the time to really just explain some of his perspectives and experiences when it comes to these situations, when things are getting a little bit sticky, when things are getting stressful, when things are definitely starting to have friction in our real estate transactions, whether it's before or after the transaction. Again, this is something that I don't see a lot of people talking about, so really encourage you guys to share this video everywhere, because we're constantly trying to provide you value. And speaking of value, we've also got a survey that we'd love for you guys to fill out and let us know, what are we doing right? What are we doing wrong? What would you like to see more of on this channel? Because we've talked for thousands of hours now about Canadian real estate investing. There's probably thousands of hours more we could talk about, but we'd love to be talking about the things you want us to talk about. So let us know via the survey. Otherwise, smash the like button, hit subscribe, and I'll see you in the next video.